Hi guys. So we are on chapter 20 on International Humanitarian Law, IHL. So if in the previous chapter we were dealing mostly with use ad bellum, or the conditions that would justify the use of force and international efforts to curtail and to limit those conditions that would lead or would escalate into all-out warfare. In this chapter, we're dealing with the law of armed conflict, or international humanitarian law, which deals basically with creating humane conditions after hostilities and after conflict has broken out. So the primary focus and emphasis in international humanitarian law is to limit the, the effects of armed conflict by protecting persons who are not or no longer are participating in hostilities, also known as civilians, and to restrict and regularize the means and methods of warfare available to combatants. So the main principles of international humanitarian law are: number one, justified application in terms of intensity and methodology of kinetic force necessary to achieve military objectives. Number two, prohibition of excessive, militarily unnecessary use of lethal force on humanitarian grounds. And number three, certain levels of chivalry and spirit of fairness that should prevail in the conduct of hostilities. So basically, there are two streams of international humanitarian law. So we have the law of The Hague, which deals with the laws of war proper, and the law of Geneva, which deals primarily with humanitarian law and protection of prisoners of war and civilians and so forth. So the early period in the development of IHL, International Humanitarian Law, is defined by the Paris Declaration of 1856, which is issued after the end of the Crimean War. Some people have termed the Crimean War the last pre-modern warfare. And the Paris Declaration of 1856, remember, this is only 5 years before the outbreak of the Civil War in the United States. So anyways, the Paris Declaration puts an end to the Crimean War. It abolishes privateering, and privateering was the use or the commissioning of an armed ship that is privately owned and manned to fight or harass an enemy ship. So the Paris Declaration abolishes that practice. And also it regulates the relationship between neutral and belligerent and shipping on the high seas and introducing new prize rules. During the early period, and this is after the outbreak of the American Civil War, you also have the Lieber Code, or the Lieber Act of 1863. This act is essentially a set of instructions that were signed by U.S. President Abraham Lincoln to the Union forces during the American Civil War. And by some accounts, the Lieber Code represents the first attempt to codify the laws of war. So some of the instructions for the government of the United States armies for the Union forces include humane and ethical treatment of populations in occupied areas. It forbids killing prisoners of war, POWs. It forbids the use of poisons. It forbids the use of torture to extract confessions. And it is really a precursor to the Hague Regulations of 1907 and the treaty-based restatement of the customary law of war. So, like I said, this is an attempt to codify these customary laws of warfare. So next you have the Hague tradition, and we've covered this in the previous chapter, the two Hague conferences of 1899 and 1907, which determined the rights and duties of belligerents in the conduct of operations and limits the choice of means in doing harm. And it comes up with a definition of combatants. It establishes rules relating to the means and methods of warfare, and it examines the issue of military objectives, military necessity, distinction between combatants and civilians, and proportionality principle, that there should be some level of proportionality or commensurability between the methods used and the objectives sought. Then you have the Geneva tradition and the four treaties. These are very well-known treaties in international law. The four treaties and three additional protocols that collectively create and codify the Geneva tradition. So the broad objective of the Geneva tradition is to establish the standards of international law for the humanitarian treatment of war. Remember, we were here trying to humanize warfare. So the four Geneva treaties are the First Geneva Convention of 1949, which deals with the amelioration of the condition of the wounded and sick in armed forces in the field. The Second Geneva Convention of 1949 deals with the amelioration of the condition of wounded, sick, and shipwrecked members of armed forces at sea. The Third Geneva Convention of 1949 is focused on the treatment of prisoners of war, or POWs. And the Fourth Geneva Convention is primarily focused on the protection of civilian prisoners in time of warfare. Then you have the three protocols that came into force in 1977, the two of them in 1977 and the last one in 2005. Protocol 1 deals with protection of victims of international armed conflicts. Protocol 2 deals with protection of victims of non-international armed conflicts. And the third protocol is focused on adoption of an additional distinctive emblem, which is a technical issue not dealing with in detail here. So, Common Article 2 of the four Geneva Conventions. And Article 2 reads, "The present convention shall apply to all cases of declared war or of any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by one of them. The convention shall also apply to all cases of partial or total occupation of the territory of the high contracting party, even if the said occupation meets with no armed resistance." And it continues on stipulating, although one of the powers in conflict may not be a party to the present convention, the powers who are parties thereto shall remain bound by it in their mutual relations. So there's no reciprocity here, essentially. And they shall furthermore be bound by the convention in relation to the said power if the latter accepts and applies the provisions thereof. So here we have a typology of war crimes that, and they are categorized into four broad types of war crimes. One, violation of warfare law, conventional or customary. Number two, hostile armed acts committed by non-members of recognized armed forces. Number three, espionage, sabotage, or war treason. And number four, all marauding acts. Marauding meaning going, from place to place, going around in quest for plunder or making a raid for booty, or killing or destroying property and so forth. All right, so here we are trying to define who is a lawful or privileged combatant so that they could enjoy those protections under the Geneva Conventions and Geneva Protocols. So, lawful combatants are commanded by a person responsible for his subordinates. They have a fixed, distinctive emblem recognizable at a distance. Remember, the third protocol of the Geneva tradition dealt with this issue of emblems, and that was an effort to make these lawful combatants recognizable via their emblem. A lawful combatant carries arms openly. A lawful combatant carries out operations in keeping with laws and customs of war. And if captured, POW status will be granted to these lawful combatants in accordance and in keeping with the Third Geneva Convention. Please note that the term unlawful combatant that we've been hearing a lot after 9/11 and after Operation Enduring Freedom in Afghanistan, this term unlawful combatant is not mentioned in either the Hague or the Geneva Conventions. An unlawful combatant is someone who commits belligerent acts but does not qualify for POW status under Articles 4 and 5 of the Third Geneva Convention. An example of an unlawful combatant would be, for example, a mercenary. All right, so according to the Third Geneva Convention, POWs are the responsibility of the state, not the persons who captured them. So they enjoy this protected status because it falls under the responsibility of the state. And according to Article 12 of the Third Geneva Convention, POWs may not be transferred to a state that is not party to the convention. According to Article 13 to 16 of the convention, POWs must be treated humanely without any adverse discrimination, and that their medical needs must be met. Article 17 stipulates that every prisoner of war, when questioned on the subject, is bound to give only his surname, first names, and rank, date of birth, and army, regimental, personal, or serial number. Article 19 stipulates that prisoners of war shall be evacuated as soon as possible after their capture to camps situated in the area far enough from the combat zone for them to be out of danger. And Article 85 of the Third Geneva Convention deals with offenses that were committed before capture by these POWs. According to this article, prisoners of war prosecuted under the laws of the detaining power for acts committed prior to capture shall retain, even if convicted, the benefits of the present conviction. All right. Again, one of the interesting aspects of international humanitarian law and the Geneva Conventions and Protocols is the United States legal system and this new category of unlawful / illegal / unprivileged combatant or belligerents. And there are a couple of cases that dealt with this question of unlawful combatants during the Bush administration. One of the more well-known ones was Rasul versus Bush and Hamid versus Rumsfeld. In 2002, in its ruling on this case, the U.S. Supreme Court recognized the power of the government to detain enemy combatants, including U.S. citizens, but ruled that detainees who are U.S. citizens must have the right of due process and the ability to challenge their enemy combatant status before an impartial authority. Then the Bush administration responded to the ruling by setting up the Combatant Status Review Tribunals, the CSRTs. And these were set up for confirming whether detainees held at the Guantanamo Bay Detention Camp, Gitmo, had been correctly designated as enemy combatants. Then you had Hamdan versus Rumsfeld case in 2006, where the Supreme Court held that the Combatant Status Review Tribunals, the CSRTs, set up to try detainees at Guantanamo Bay, lacked the power to proceed because the structures and procedures of these CSRTs violated both the Uniform Code of Military Justice and the 4 Geneva Conventions signed in 1949, specifically Common Article 3 of the Geneva Conventions. Then the Bush administration's response was the Military Commissions Act of 2006. And this was an act of Congress signed by Bush in 2006 to authorize trial by military commission for violations of the law of war. Now, what was the definition of unlawful enemy combatant in U.S. law? This term means, according to U.S. law, 1, a person who has engaged in hostilities who has purposefully and materially supported hostilities against the United States or its co-belligerents, who is not a lawful enemy combatant, including a person who was part of the Taliban, Al-Qaeda, or associated forces, or number 2, a person who before, on, or after the date of the enactment of the Military Commissions Act of 2006 has been determined to be an unlawful enemy combatant by a Combatant Status Review Tribunal or another competent tribunal established under the authority of the President or the Secretary of Defense. So it just leaves it at the discretion of the executive branch, essentially, to determine who is an unlawful enemy combatant. Now back to the United Nations and international efforts to limit the means of war. To deal with the question of conventional weapons, you have the United Nations Convention on Certain Conventional Weapons, CCW of 1980. Protocol 1 deals with non-detectable fragments. Protocol 2 deals with mines, booby traps, and other devices. Protocol 3 with incendiary weapons. Protocol 4 with blinding laser weapons. And Protocol 5 with explosive remnants of war. So these are protocols dealing with or focused on limiting the means of war, the conventional means of war. Then you had the Ottawa Treaty of 1977, whose main aim was to ban the application of mines. And the Ottawa Treaty of 1997 sought to stop the production and development of anti-personnel mines. These are known as AP mines. Also, it sought to destroy a stockpile of anti-personnel mines within 4 years. But it was not very successful because China, the United States, and Russia have not signed the Anti-Personnel Mine Treaty of 1997. So moving away from conventional weapons and restricting conventional weapons, the international community has also tried to abolish or significantly curtail the proliferation of chemical, biological, and nuclear weapons. On nuclear weapons, you have the chemical weapons, on chemical weapons, you have the Chemical Weapons Convention, the CWC of 1992. This is a convention that is administered by the Organization for the Prohibition of Chemical Weapons, OPCW. The key provisions here are prohibition of production and use of chemical weapons, destruction of chemical weapons production facilities, destruction of all chemical weapons, assistance between state parties and the OPCW in the case of use of chemical weapons. This is what happened in the case of Bashar al-Assad in Syria and his alleged use of chemical weapons. Also, the Chemical Weapons Convention, through the Organization for the Prohibition of Chemical Weapons, established an OPCW inspection regime for the production of chemicals which might be converted to chemical weapons. So essentially a control regime for the production of such chemicals which might have weaponization uses as well. So these are dual-use chemicals. And finally, international cooperation in the peaceful use of chemistry in relevant areas. In terms of membership of CWC, of the 6 states that are not parties to the treaty, 2 have signed but not yet ratified the treaty, and these are Burma and Israel, and 4 states have not acceded to the treaty, and these are Angola, North Korea, Egypt, and South Sudan. Remember that that this list might have changed slightly since the latest edition of the book, so this might not be the most updated information on the Chemical Weapons Convention. And next we have the international mechanisms dealing with nuclear weapons. So the cornerstone treaty here is the Non-Proliferation Treaty, which has an executive body known as the IAEA, or International Atomic Energy Agency. So the Non-Proliferation Treaty and the International Atomic Energy Agency work in tandem and in concert with one another in order to advance the objective of curtailing and controlling and preventing the proliferation of nuclear weapons. You also have a few other mechanisms that we might have touched upon briefly before: the Partial Test Ban Treaty, which was ratified, which came into force in the 1960s. Also, the Comprehensive Test Ban Treaty, CDPT, which has not come into force yet. Also, you have the so-called NWFZs, or nuclear weapons free zones. There's 9 of these NWFZs in totals. In total, 5 zones cover continental or subcontinental groups of countries, Latin America, Caribbean, South Pacific, ASEAN, Central Asia, and Africa. You have 1 UN recognized zone consisting of a single country, that's Mongolia, and you have 3 governing Antarctica, the seabed, and outer states. So together, these mechanisms and treaties and nuclear weapons free zones are the methodology that the United Nations and the international community has come up with to prevent the spread of nuclear weapons. All right.